Yes, Mr.
Please, my lord, remember yesterday's last item that I have been refiled the bail. So notice she needs to be called for month. So
Can you get it before 12 o'clock?
My lord.
Can you get it?
Yes, my lord. That
Then
already,
get it. I'll do it.
that already filed.
12 बजे का पहले लीजिए. List खत्म होने का पहले call कर लीजिए.
May I, Your Lordship?
Yes.
Lordship, I would like to mention for an unlisted matter.
Today.
Yes, Lordship,
is the
for
matter?
today. Lordship, it's related to a private land dispute, Lordship.
What is
May the matter be
what is
listed
the
for-
imminent threat now?
Lordship, actually, since it's related to a private land dispute, the residential house of the petitioner is being dismantled due to like heavy rainfall. So he is unable to renovate the residential plot of land, and therefore, Lordship,
Is there
he
a
is in very
threat of
pathetic.
eviction immediately?
Yes, Lordship, he is in very like pathetic condition. Therefore,
No, no,
Lordship,
no.
it's urgent.
The house has been evicted already.
Not evicted, Lordship, but it's like in very pathetic condition, Lordship. Therefore.
Pathetic condition.
Yes,
Can it
Lordship.
wait till Tuesday? If not, otherwise inconvenient.
Lordship, actually, this matter is related to an order which has been passed by the executive magistrate, Itanagar.
What is the order?
Order where it has passed an order of status quo, Lordship.
Then
So
what
it has passed under section 145 and 146 of CRPC.
You file your replies there.
Yes, Lordship, this is an like revision petition which has been passed for an order which has been passed by the session court, Lordship. May the matter be listed for today, Lordship, please.
But get it before 12. Second half, this court may not.
After 12, Lordship.
Before 12? If
Before
possible.
12.
It's already filed.
Yes, Lordship.
Then
Lordship, if after 12,
get.
okay. Lordship.
What has happened to the maintenance case? It's still pending.
Pending.
No final.
No.
And the husband is regularly
Attending
participating.
Next date is on 7 December.
In that maintenance case.
Maintenance.
And this one?
This one is on 14th
14th of?
December.
So what we do is, we have gone through the thing. That husband is already participating in a proceeding there. And your case is that you have a son and you have a service there.
Yes.
So in that view of the matter, it may not be possible for you to commute to here. So there has to be a middle way.
Sure.
And is the relation gone so bad that it cannot be mended through a process of mediation or something?
From my side,
There is nothing.
there's nothing. I have persuaded and I have
We'll
tried.
issue a notice, let him come, then we will try. Let the husband come, we will try.
Lordship, I have prayed for.
Stay, we'll have you there. Lekho. Heard your name?
Our Queen.
R. Queen, learned counsel for the petitioner. Also, the petitioner has instituted the present proceedings, assailing present proceedings under section 24 of the Code of Civil Procedure 1908, seeking transfer of title suit number 50, just correct me if I am wrong, 50 of 2023, presently pending before the District and Session Judge Upia, to the Court of District and Session Judge Teju, Lohit District. Right? Full stop. The said title to suit was instituted by the sole respondent, husband of the petitioner, seeking divorce. Full stop. The petitioner has contended that she is presently serving in Rowing and has a minor child. And in that view of the matter, it would not be possible for her to pursue the said title suit before the Court of District and Session Judge Upia. Full stop. The petitioner has also contended that she had instituted a maintenance case being maintenance case number 06-2023 before the court of Chief Judicial Magistrate Ruing, and the sole respondent is participating in the said proceeding without any objection. Full stop. Issue notice, returnable 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the sole respondent by way of registered post as well as usual service. Full stop. Upon consideration of the materials available on record and also the submission advanced by the counsel for the petitioner, it is directed that the further proceedings in title suit bracketed divorce, no?
Yes.
Bracketed divorce number 50 of 2023, pending before the Court of District and Session Judge Upia shall remain stayed/suspended till the next returnable date. Full stop. Okay, Jitu, forward question, issue notice returnable after 4 weeks, on a date to be fixed by the registry. Okay, sir?
Much.
Wait, Ms. Lordship. This is a joint application by the husband and wife. Offense is
Mr. Saxena, there was a mail earlier and therein.
Lordship, that was not a mail actually.
No, it was somewhat sort
Yes.
of a compromise.
Between the
And
families.
our families and you had even
I
said
agree.
that you
I
agreed,
agree.
but then you again come back to your present ways. Yesterday, there was a matter, similar matter. And in principle, we agreed that we will quash those proceedings following the Supreme Court directions. But there was an objection raised. Then we had called the parties.
Yes.
We had called the parties because they were from nearby. And thereafter, the matter is now presently CAV. The judgment would come.
Lordship, if
Here,
you-
only thing which they may take up that objection also. If you come to your affidavit,
Yes.
page 9.
Yes, no.
Otherwise, I have gone through the issues are very clear. There's nothing there. The wife has also in categorical terms said she does not want to proceed. You have seen the signature of the lady,
Yes.
Tume Riba. Come
Yes.
to page 10. Have you seen the signature there? T Riba, down below.
Yes, Lordship.
Now you
Actually,
come to the compromise,
Yes, Lordship.
page 46. Have you seen that signature?
In fact, Lordship can see who has identified.
I got it. I'm not on that. I'm
In
not
my
on-
chamber, in my
I'm not
chamber.
on that, but
They both were present.
if they don't take an objection to that,
They both were present in my presence.
okay. I'll put it on you then.
Yes.
What do you say?
It's a, if we peruse page number, this one, affidavit, it's a full signature, my lord.
Fine.
It's a short-
He
it's a short
says
one.
that, and counsel of the court saying
Yes, my
that these two persons have signed before me. I think we'll have to give
Yes.
them 15. So when is the next date fixed?
7 December.
7 December. So you have any objection?
No, my lord, since this
Compromise, let
covers
them
by
leave
the
peacefully.
parameter of,
Let them
That's
please
been
leave
a-
peacefully. So what I do is I'll make it CAV and you will have the order by Wednesday or Thursday. Because I'll not be here for 2 days. Wednesday or Thursday, I'll pass this order.
Highly honored.
Heard Mr. K. Saxena, learned counsel for the petitioners. Also heard
Jambe Tsering, J Tsering,
J.
Tsering,
Charia for, you are the
PP.
additional PP,
PP,
PP, the public prosecutor for the respondents. Full stop. I'll just put this observation of mine in your mouth
yes,
so that we can get a full stop. The learned PP, by drawing my attention to the various signatures of the different signatures of the petition number 2 available in the records of the present proceedings, raised a doubt as to whether the petition number 2 had signed on the compromise agreement available at Annexure 4, page 44 to the petition. Full stop. Mr. Kamal Saxena, by drawing my attention to the deed of agreement, has submitted that both the petitioners were identified by him in the said deed of agreement, and as such, there can be no doubt that the signature in the deed of agreement is of the petitioner number 2. Full stop. In that view of the matter, the apprehension raised by the learned PP is addressed. Full stop. Heard the parties to the proceedings. Hearing arguments concluded, judgment reserved. Okay. Obligation.
Lordship, I'm on behalf of, praying on behalf of DK Jerry for the matter to be passed over for time being.
Lordship, I have spoke to him just now, just before. Lordship, this may be fixed on December 5th.
December 5th.
Pleading is complete here.
Reading is complete.
Complete, yes. For admission hearing. Lordship.
See,
For
Madam,
admission hearing.
just one clarification I would like to have.
Yes, Lordship.
See, pensionary matters delay normal. It happens. But don't you have a provision for paying provisional pension in the meantime?
They do pay.
But why is it not
Gratuity and GPF and all, they do.
No.
They do.
provisional pension? You finalize your pension, but the
Yes.
department can make a provision for, because see, this man for last around how many, 2-3 years have now without pension. I've seen a few cases also. Don't you have a provision wherein you can, the department, it's in Assam, we have this. The
Lordship,
pension is paid either by the AG or by the Director of Pensions.
Director of Pension.
So the pension papers, it takes time. It's a cumbersome process. It takes time because they also, the employees also before 6 months never give. After retirement, they give. So in the interregnum, even in the FRSR, it's there is a provision that for 1 year you can give. But there, it has been made permanent that till the final pension is settled, the provisional pension would be given.
Lordship,
Just have a talk with your
Yes, I'll
director.
take
That
instruction
will be
to this.
that will be beneficial for the
Yes, I
common,
understand.
for the employees also, because you are not losing anything. The moment the pension is clear,
Lordship.
this amount would be deducted, and it will be little bit lower. Say you get 5,000 pension,
Mm.
but when you give provisional pension, you may be giving him 4,500. So when the final pension is settled, this would be adjusted because that will come there, recoveries. It will come as recoveries and it will be adjusted.
Agreed.
So
Lordship.
kindly have, because otherwise, in this case, what I find is the person, I know there was a thing, he built the house, everything, but you exonerated him. And now the SP is writing, don't issue any NOCs in your affidavit that is there, that document is there.
Lordship.
Don't issue any NOCs. How can that be done?
Lordship.
Because pension, you can't, if you have anything against him, you still have time, you can proceed, but not in this manner. Kindly look, when do you want this matter? Why December?
Lordship, this is today's
What
25 only. 24.
So we'll have it on,
On 5th. Lordship. I have spoken to him. We have better than-
on 5th.
Yes, sir.
On 5th, we'll dispose it off.
Yes, Lord.
We'll keep it for admission hearing.
Admission hearing. Yes, Lord.
Yes, my lord, I just reached.
Uh-huh.
I had just taken
They
that.
want some time. So, madam, and you also have this instructions.
I will take the
You
instruction.
just have the instruction.
I'll come with the instruction.
Please do so. On the prayer made by Lord Leonard so and so for the appearing for all the respondents,
Yes, Lordship.
for all the respondents, comma, list these matters on 5/12/2023. Full stop. Also heard Mr. S.K. Dury,
DK.
D.K. Dury. S.K. is the senior one.
Yes.
D.K. Dury for the petitioners. Full stop. On the next date fixed, an endeavor would be made to dispose of the present petition.
Much obliged.
Now you have that instruction. That will be helpful for all.
Surely, surely.
You are appearing for the,
State, my lord.
who is there for the petition? No. Whoa, what is the problem here? Who is appearing for the, what do you call, the treasury officer here? Respond number 7. Ma'am, why don't you have an instruction? Because see, when the pensions are issued, there will be 2 halves. One comes to you and the other goes to the pensioner. So in your half, because she lost it, in your half, if that endorsement is that the petitioner is the wife, there can be no problem. Only a formality has to be done.
Yes, my lord.
Can you get that instruction? Because what has happened here, if you come to the affidavit filed by the Director of Audit,
Yes, my lord.
page 5, the last line. In this regard, you're competent to issue a duplicate pensioner portion of so-and-so under Rule 331 of so-and-so for further processing of the family pension. So you have that instruction as to why it was not done. I'll not record it. Should I record it?
No.
No. None appears on behalf of the petitioners on call. MS so-and-so appears on behalf of all the respondents, ma'am?
No, my lord. 1, 5, 6, and 7.
On behalf of 1, 5, 6, and 7.
And for 2, 3, 4. Your lord.
And Mr. So-and-so appears for 2, 3, and 4. Full stop. For the ends of justice, the matter stands adjourned to be listed on, let's have it on 4th.
4th December.
4th this week. Can you get the instructions by that time? On 4th December 2023. I'll just make an observation, or else I'll forget. Miss so-and-so, appearing for the respondent number 7, is requested to receive instructions from the Treasury officer as to the steps taken by the authority, by the said authority, in pursuance to the communication dated 27/3/2023, issued by the Director of Audit and Pension, Government of Arunachal Pradesh, Naharlagul, annexed as Annexure I to the affidavit filed by the respondent number 5. Maybe you just bring it to his notice. So you don't leave this place also. Now you have come here also.
No, no, I've been coming here since.
Now he is there everywhere in Guwahati. So I said that this was safe. He is here also.
May it please your lordship, my lord.
What is to be done here today?
My lord,
Because see, the matter that is there,
yes,
an argument can always be developed.
Yes.
That there is some, just putting in simple, there is something which may require a trial. So in that view of the matter, whether powers under 482 should be exercised in this case. It will require a lot of in-depth. So if I have to go that deep,
yes,
why should I even entertain this?
I got it, because probably what your lordship is hinting towards is that if under 482, if your lordship needs to get so deep, so why don't I leave it to the trial court and why should under 482? My lord, I'll satisfy your lordship because here is a issue of jurisdiction.
That I got. You
Here
have
is an
taken
issue
that.
of jurisdiction, my lord, because this order and the entire mail proceeding lacks jurisdiction.
7 lakhs you gave, date was wrong.
5 lakhs.
16, 5 lakhs. 18 it be, no, it's.
No, 5 lakhs I have taken, 7 lakhs I have given.
Yeah,
Yes.
you wrote 8/6/2016, but it became 18
My lord. My lord.
in the check,
My-
so that it could not be encashed.
No,
So
no.
what I propose is, this will take some time.
Absolutely.
This will take some time. So when are you coming back?
Next Thursday?
Thursday.
Next.
So we'll fix it on Thursday.
my lord.
And if there is no other inconvenience on the part of
No,
the,
Your Lordship, we are in fact prepared for this case or otherwise.
but see, this will take some time.
Yes, sir.
And starting off, I don't want to start off with a negative manner.
It will take time.
It will take time. So unfortunately, I would not be here in the second half in all probability, subject to the unlisted things. So we'll fix it on Thursday, and on that day,
According to respondent's convenience, Your Lordship.
yes, if you are convenient.
My lord, if I may, if I can be accommodated on the second week of December, Lordship.
December 2nd week.
Second week of December.
Subject to my,
Fix that, Lord.
Is-
Second week of December.
you fix a date whenever it's convenient. We'll have a regular bench, criminal bench on that day.
My lord, Thursday is convenient. He'll be here on.
Seven.
30.
Lordship, I won't be in station on 30.
Then 29?
20, whenever it's convenient.
29?
Fix a date. Or do one thing. You have a cup of tea, fix a date, and then come and tell it. Heard the learned counsel for the parties on the prayer made by the parties to the proceedings. List the matter again on so and so. Dash, huh? Did give. Interim order passed earlier shall continue till the next date of listing. But if we have to go, I just disclose my mind. If we have to go that deep, why 482?
My lord,
Jurisdiction is an issue which you can still raise before the,
my lord, I would have loved to have argued it before your lordship, my lord, because I'll satisfy your lordship that I will not touch upon any fact where there is a dispute. I will only address this court on the point of law.
see, now the proceedings are before a court of law.
My lord.
It's not before the thing. So these are arguments which you can raise there also.
For that, an entire full-fledged trial my client will have to face.
Fine.
And if the-
I'll also try to read it once more and try
Absolutely.
to mold down myself a little bit, if possible. Thank you. Thank you.
May I, my lord? My lord, item number 6 on the last occasion, we have sought for the case diary, but we haven't received it today, my lord.
Wait,
This
the
matter
case
can-
diary required here now. Council, in such matters, you will have to satisfy me on 2 counts.
Yes, Lordship.
NDPS, other matters, it's no, this is a crime against the society. Supreme Court has also said that we should be very careful, not lenient.
Yes, Lordship.
2 things. 1, your antecedents. Or maybe 3 if I can put it. 2, the recovery part. And the third thing, most important, is that if I release you on bail, you will not go back to that. In this case, I find that the recovery was made from you. There is nothing on record in the application countering that. 1, just broad thinking, loud thinking. 2, antecedents. You have annexed orders passed against you by the sessions court. Rightly so. You have not suppressed. I appreciate you for that. But you have not taken any stand in the pleadings that see those things are all wrong. It's not correct. That means what? You had an NDPS case before also. You have a criminal record. Now, in that case, you got bail, came out, and again you are indulging. This case, how can I? So try better luck somewhere. And he's also asking for an adjournment. So it's better. Because these 2 things have to be satisfied. Otherwise,
We'll
yesterday
have to
also-
overcome the 2 tests.
two things. If you want those judgments, I can have it.
Yes.
Because otherwise, I think it's 2007, 7 SCC, 79. 2007, 7 SCC, 29, wherein the parameters have been laid down with regard to 37. There are subsequent judgments also. Go through that once. But the counsel for the, heard Mr. So-and-so. Counsel for the applicant also heard Mr. So-and-so, PP, learned PP for the state respondents. Full stop. The learned PP submits that the case diary as called for by this court wide order dated 16/11/23 has not been received, and this is by the officer and prays that the matter be taken up on when?
Tuesday.
Tuesday on so and so for production of the case diary. Can take this back.
May I please, madam? This was
22nd. Both of us have agreed on 22nd of Jan.
Jan, fine. You are very happy. You have a stay order.
Madam, this matter was listed on being mentioned by me yesterday. madam.
Hmm.
And the basic grievance of this madam petitioner is that, madam. The lane has been acquired.
Now tell me one thing,
Fine.
Mr. Srigar, before sorry, I'm
Why,
interrupting.
madam?
When was the award finalized? Because
Award-
see,
Yes.
100% solicitation, if I have to order, I'll have to say that your case is covered by the 2013 Act,
Yes. Exactly.
right? Now, from the proceedings that I find is that the award was sanctioned and it was approved by the government sometime in 2013
13, madam.
itself. So you don't have,
And the my lord, Yeah.
and this whole proceeding is not under the 47 regulation, it is under the 1894
yes, madam.
Land LA
Right,
Act.
madam.
Good.
Then, my lord, the amount was, my lord, only deposited in the year 2018, pursuant to an order passed by this honorable court, my lord.
In 17.
My lord.
Mm.
And the amount was deposited in 2018.
And you have withdrawn that amount under
Withdrawn-
protest.
withdrawn that, my lord. Now, my lord, I am only seeking solution and the 100% in
No,
terms
for
of.
that solution, you will have to also bring yourself within that para 24, section
Yes,
24.
section 24, my lord.
Mm.
Yes, madam.
Mm.
Yes, because, my lord, section 24 says, my lord,
24 2.
24 2, my lord.
Mm. 24 1 you will not be covered because that is satisfied.
9,
Now we come to 2.
where
Notwithstanding, it's a
an award
non-obstante
under
clause.
Section 11 has been made, and such proceedings shall continue under this provision.
Forget it, you come to section 2.
Section 2, my
Oh.
lord, and the last,
24 2.
yes, 24 2, my lord.
Nothing,
Notwithstanding,
notwithstanding.
contained in subsection 1 in case of land acquisition proceeding initiated under Land Acquisition Act 1894, where an award under the state act section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken, or, my lord, the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it chooses, shall initiate the proceeding of such land acquisition afresh in accordance with the provisions of this act. Now, my lord, proviso is
See the
that,
proviso.
proviso, my lord.
Mm.
Provided that there where an award has been made and compensation in respect of the majority of the matter, land holdings matter, has not been deposited in the account of the beneficiaries, then all the beneficiaries specified in the notification for acquisition under the section 4 of the said land acquisition act shall entitled to compensation in accordance with the provisions of this act, my lord. Now, my lord, preliminary
no,
notification
no.
was issued.
Now, 2
Yeah.
has certain layers. It says where an award under section 11 has been made 5 years or more prior to commencement of this act.
Yeah.
Your thing will not be covered by that because your award was of 2013
13, my
and immediately possession was taken,
lord.
right? Now, but the physical possession of the land has not been taken, so that will not cover. Secondly, the compensation has not been paid and the said proceeding shall be deemed to have been land. So this compensation not paid
Yes, madam.
is not 5 years after coming into force of this act. It is for an award passed 5 years prior to
Prior to the matter,
the coming into force.
Yes.
Get a judgment on this.
my lord. I have the judgment, my lord.
Covering this point.
Yes, my lord. This has been settled, my lord. my lord.
Indore. Indore.
Indore, my lord. My lord, Indore Development Authority, 2028 SSC, one, my lord, I have given the book, my lord.
You are appearing for?
Sir, Deputy Commissioner.
Of the deputy commissioner.
collector.
NTPC, nobody, because they say we have given, nothing is there.
My lord, come to directly page 393, my lord. Paragraph, my lord. 366.4, my lord. 392, my lord.
Conclusions.
My lord. Conclusion. And 3664, my lord. May I read, my lord? The expression paid in the main part of the section 24(2) of the 2013 Act does not include a deposit of compensation in the code. The consequence of the non-deposit is provided to section 24(2). In case it has not been deposited with respect to the majority of land holding, then all the beneficiaries, landowners as on date of the notification for the land acquisition under section 4 of the 1894 Act shall be entitled to compensation in accordance with the provisions of the 2013 Act. In the case obligations under section 31 of the matter.
You come to 3363. 3363.
363.
No, that only. Page
Okay.
393,
Yes,
para 366.3.
yes, ma'am.
The word,
The word or used in section 24(2) between possession and the compensation has to be read as nor
Nor.
and or as and manner.
the deemed lapse of
The deemed
land.
lapse of the acquisition proceeding under section 24(2) of the Act 13 Act takes place where due to inaction of the authorities for the 5 years, my lord, or more prior to the commencement of the said act, the possession of the land has not been taken or nor compensation has been paid.
So that's what I'm
That-
saying. So you're here, this is what distinguishing, because all other cases we find awards were issued 5 years, 6 years, but nothing was done. Here is a case wherein simultaneous to the promulgation of this 2013 Act, just before that, the awards were made. And it was notified, government approved. So section 11 satisfied.
Yes, ma'am.
So if we go by plain and simple 24(1), your thing will not come under 23, the 2013 Act.
Yes, sir.
Now, 24(2), you will have to take recourse to, and you have taken recourse to
Right.
that. Therein it starts with the word, the subsequent portion, possession and compensation. These two are in light of 5 years elapsing prior to the coming into force of the Act.
Right.
You will have to go beyond Indore. You will have to go beyond Indore. Make some research. I'll also look into it. Because, say, Indore 366.3, I may be wrong,
No,
but this is something which is troubling me. It says, nor and read again. The deemed lapse of land acquisition proceedings under so and so takes place where, due to inaction of authorities for 5 years or more, this would have been enough prior to commencement of the said act. So to bring in 24(2), we cannot ignore the opening paragraphs, and it's starts with the non-obstante clause. Leave everything. You will have to just work out on that. Because if you don't get 2013 coverage, you're not getting 100% solar.
Yes,
I think that's what I've understood.
Yes, yes, yes.
Please make an endeavor. We'll have it next week, no problem.
Madam,
We'll have it next week,
next week, madam, then on, madam,
whenever it's convenient to you.
4th, madam,
Fourth, fine.
already.
You have got anything to say on this?
No.
You also make some research because, see, if he is otherwise covered by the 2013 Act, then you can't deny to him the soliciting. And this is not a proceeding under the regulations of 47.
Yes.
This is a proceeding under 1894. So, but maybe I'm wrong, but this I have not been able to overcome. The 2 lines, how do you synchronize?
Yes, madam.
Because it says 5 years prior to the
Prior
act.
to that.
Then
Is the window
possession
period.
and compensation.
Yes.
So if it is not 5 years on 2013 itself, 5 years happens after 2013, whether that provision will still be applicable. We've got to find a judgment on that.
Madam.
Okay.
On 4th, madam, kindly.
Gotcha.
madam.
I'm not keeping it, Pathak.
No, no.
If I'm here, I'll take it up or the bench which is there. I'll take up.
I'll-
On the prayer made by the parties, list the matter again on 4/12/2023 for admission hearing. No?
My lord.
The admission hearing.
It's in order, my lord.
Why is it in orders?
My lord.
Hmm? It has been admitted.
It was in fact fixed for hearing.
But no. Where is Mr. Saxena? He's also filed an affidavit. He is not representing. We'll have to send somebody to call you. It's not been admitted.
My lord, may kindly admit.
No need. We'll fix it for admission here.
Right.
For admissions. It's not been admitted.
Date may be given.
4/12. What put his name also? All the three names. All the three names for the and they too for the respondents.
Obliged, my lord.
You, Mr. Sakya, just
My lord, my
check that. Mr. Saxena, you also. The provisions of 24(2) says, say 5 years have lapsed before coming in, the award is passed, 5 years have lapsed, but possession not taken or compensation not paid. Then the 24(2), the 2013 Act would apply. Now, here is a classic situation wherein 1/1/2014, the provisions of 2013 Act came. But here the award was approved, passed in 2013, later part. So that 5 years thing has not come into operation. You get my point? 5 years happened after 2013 when the deposit was made by NTPC in 2018. So whether this post 2013 Act would also be covered. That's what I require to be.
Yes, Lordship, this IA is filed in, there are two cases, Lordship. That IA is filed
30,
in,
you have 31 and 26.
yes,
right.
Lordship. That IA is filed in CRPC number 26.
Hmm.
And as per this code list, it is wrongly mentioned, Lordship.
Hmm. And wrongly listed means you let it be together because your that order is getting extended
Exactly,
in this
Lordship.
proceedings.
Exactly, Lordship.
Why is it listed today?
Lordship. And Lordship,
The
regarding,
respondents have appeared. Mr. D. Panning
yes, Lordship.
is here. Just call him. This is for delay condonation.
Yes, Lordship. Lordship, there is,
Mr. Panning, you are appearing in this case. Learned Counsel, Mr. D. Panning has appeared on behalf of the respondents, but he has not filed Wakalatnama till date. Item number 8. R.C. Laugacha is your colleague. Who is then Mr. D. Panning here? Panning? Have this.
Oh.
You have not filed your Wakalatnama. And they have a delay condonation application for around 4,000 odd days. 4,000 odd days. Objection. Regularize it immediately. No, because the office note says that you have not filed your Wakalatnama. Oh, so
And Lordship, CRP number 2026 is the same nature, 26 and 31.
IA is same, and
No,
that is
Lordship,
why they are connected together.
Only IA is filed in the 2026, Lordship.
Right. There is
Because-
an interim order in 31.
Yes, Lordship.
Fine. IA 92 of 2022 on the prayer made by Mr. Deepangi, Learned Counsel for the respond number 1, 2, and 3 to file an objection in the matter. List file an objection in the matter, and accordingly list after 2 weeks on a date to 3 weeks on a date to be fixed by the registry. Okay? Then CRP number 31 AP 2022. Heard the parties to the proceeding. List along with CRP number 26 AP 2022 after 2 weeks on a date to be fixed by the registry. Interim order passed earlier shall continue till the next returnable date.
Obliged, Lordship.
My lord, in this matter, I need some time to file wakalatnama for respondent number 2. So I had filed objection for respondent number 1.
It takes, your material instructions have come.
Yes.
Then why
Yes,
the
I will file the
wakalatnama?
wakalatnama.
No. Material instructions have come.
Yes.
Then why the wakalatnama has not come?
Today I will file.
You will file today.
Yeah, I will file.
So what, you will file an objections here?
You know, for respondent number 1, yes, I had filed an objection. For 2 also, if required, then I will file.
You have filed for 1.
1. So there is a delay of 3,000 some days.
But that's not material. But the reasoning, if you are not contesting, then we can go ahead and consider.
Yes, I am.
But if you are considering contesting, then we'll have to give you some time. Heard Mr. D.K. Dory, Learned Counsel for the, we'll say for respondent number 1 and 2, both.
Yeah.
For respondents number 1 and 2. Praise for 2 weeks further time.
Right.
To file objections on behalf of, you have filed on behalf of respondent number 1.
1 I have.
On behalf of respondent number 2. No, you have not filed any objections here.
Objection I had filed.
Fine.
Yes.
On behalf of the respondents precatory. Okay, you have filed. No. When did you file? Objection for respondent number 1?
The initial on the 3rd day. I don't remember. Even I have not recorded. I will check it. Along with the wakalatnama I had filed.
In the IA. What? On behalf of respondent number 2, right here. There is nothing here which shows that you have filed it. Take it even, you filed for our legal opinion. About line net code use. Mr. DK Deori submits,
Last December,
submits that he has already filed objections in the interlocutory application on behalf of the respondent number 1, Rajan Newly. However, the same is not tagged with the records. Full stop. The registry is directed to locate the said objection and tag the same along with the records of the interlocutory application. Okay? You just check up once.
Much. Lordship, may. Lordship, here the service of respondent number 1 or respondent number 2 still awaited.
Awaited.
Yes.
And the respondent number 1 has also, you are appearing for respondent number 1.
Yes, Lordship.
No objections filed.
No, Lordship.
You have no objection.
We
here.
have objection.
File it.
Lordship, there is one small prayer, Lordship, if it can be considered. Lordship, I've been informed that due to the pendency of the appeal, although it is not admitted till yet, the claimant is facing difficulties in the execution proceeding before the learned tribunal. So if an order, in the order a line may be added that the proceedings may go on.
It will be dangerous because we have to consider this. They don't have they'll understand because there is no stay order passed by this court.
There is no stay
How
order.
can I enter into that without first condoning this? And if you don't file an objection,
Yes, Lordship.
how can you take advantage of that? You file an objection, we'll finish it off.
Lordship.
Mr.
Lordship,
So-and-so,
Lordship,
appearing
may.
for the respondent number 1.
Lordship, may. Lordship, small clear. Lordship, with regard to service upon respondent number 2, I may be allowed to take to substitute manner by publication in the newspaper, local newspaper. This Lordship, I have already taken fresh steps also. However, the service is still not completed. Because of this, Lordship, the
Where is she from?
he's from
Can't you take Dasti?
Dusty, Lordship, if it can be done through substituted manner, Lordship, by publication.
See, substitute manner, will you try Dasti because these people are there in the remote villages. They may not even have an access to the paper.
Lordship,
So that we'll have to keep in mind. Why don't you take Dasti?
Lordship,
Send your officer, get it signed.
yes, Lordship.
Full stop. Heard Mr. So-and-so, counsel for the petitioner. Full stop. The service report on respondent number 2 is still awaited. Full stop. Mr. So-and-so, learned counsel for the petitioner, prays that he be permitted to take fresh steps upon the respondent number 2 through by way of Dasti. Full stop. The petition is permitted to take fresh service of notice upon respondent number 2 by way of Dasti, routed through the registry of this court. Full stop. On effecting service of notice upon the respondent number 2, affidavit on behalf of the petitioner, bringing on record such service be filed. Full stop. The learned counsel appearing for the respondent number 1 prays that he be granted. We'll give you 4 weeks now because the stay is also being done. 4 weeks time I'm giving you. 4 weeks time to file objections on behalf of the respondent number 1. Full stop. List the matter after 4 weeks on a date to be fixed by the registry. Okay.
Much obliged.
You were ordered Dusty, but you have not filed the affidavit.
Yes, Lordship, I'll be filing it
Today?
today. Yes, the service is completed. Lordship.
Okay. So, Mr. So-and-so, learned counsel for the petitioner, submits that the service of notice upon the respondent number 2 and 3, no?
Yes, Lordship.
Respondent number 2 and 3 has been effected by way of Dasti service and prays that we granted 10 days time to file the affidavit in terms of the order dated 24/7/2023. Full stop. Accordingly, list the matter after 2 weeks. In the meanwhile, the petitioner is to bring on record by way of an affidavit the service, records of service effected on the respondent number 2 and 3 by way of the state board.
Give your blessing.
May I appear, Your Lordship? My lord, here, my lord, service report is related, my lord, as per office note dated 23/11.
You have come all the way from Guwahati only to say that the service is related. Huh?
Unfortunately, I have, do not know this matter was listed.
When you have too many matters, that is the problem.
Yes, ma'am.
So what is to be done?
Await service report.
The office note dated 23/11/2023 indicates that the service upon respondent number 1 to 31 and 34 is not complete. Full stop. Accordingly, await service report. Accordingly, await service report.
There is an interim order.
The interim order passed earlier shall continue till the next date of listing.
Obliged.
Please, Your Lordship. Two ways to file. First one is filed for delayed condemnation, Lordship. And second one is for day of operation, Lordship.
Notices have not been issued.
Yes, Lordship. The execution case is filed.
Without touching this, how can I go into that? So we'll issue a notice here. And then let's see. Next date, if they come, we will take up both together.
Lordship.
IA number 180 of 2023. Heard Mr.
M.K. Neupal.
M. Kejung appearing on behalf of the petitioner. Full stop. The petitioner, by way of the present application, has prayed for condonation of a delay of 138 days in preferring the connected appeal. Full stop. The appeal is instituted against the judgment and award. Award, है ना?
Award.
Passed by the motor act member, passed by the learned member, MACT, Alo, West Siang, in MACT case number 2 of 2022. Full stop. Issue notice returnable by issue notice upon all the respondents, returnable by 4 weeks. Full stops. Subpara. The petitioner to take steps for service of notice upon the respondent number 1, 2, 3, 4, and 5 by way of registered post with AD as well as usual mode.
And second one, Lordship.
No, second one. Second one is
For a stay of operation, Lordship.
that we will do only after this.
Notice can be.
Because I can't even touch that. I'm really surprised that even the appeals are getting registered without the delay is being condoned. So let the delay be condoned and then we will see.
Obliged.
May I, my lord? In this case, LCR was called for, my lord.
LCR has come.
Yes, ma'am. This matter may be fixed on 30. Okay. 30 of this month.
Then PP, what is to be done in such matters?
My lord, if we peruse page number 11 of the LCR,
Hmm.
The nature and the gravity of the offense,
Yes, that's what I
which is one of the relevant considerations.
Because
consider-
mere compromise
Yes, madam.
may not be the underlying factor. Matrimonial disputes, I understand. But in these sort of matters, 326 is again a very, I think the charges against 326, no?
24, madam. Voluntarily causing grievous hurt.
Oh. No. It's under 326.
26.
Ah, 326 IPC. Yes. Voluntary causing grievance with a.
Okay, I have been only furnished with the charge sheet, so.
No, you can
charge sheet-
have this.
Okay.
This is the one. 324 was there initially. That's why it was sent to the Lok Adalat. I was also very surprised. Then when I saw the order, it came to be my notice. It's 320. Yeah. That order, charge order is in that page. No, that. Your left hand side. So if it is 324, it would have been a different ball game altogether. So just you also check up.
Lordship.
You make a note that
Madam.
finally the charges were under 326.
326.
So it is not compoundable.
Yes, ma'am.
And whether in that view, 482 we can exercise.
That's all, yes.
So what do? We post it on?
Lordship, can it be on 30 of this month, Lordship? I have another matter, similar matter. Can be taken up together for hearing, since LCR is there, Lordship.
Same LCR for both.
No, Lordship. A different matter, my same.
So, heard Mr. Swansu, Lanark Council for the petitioner, who prays for an accommodation today and for fixing another date for hearing the matter. Full stop. Heard the Lanark PP for the state respondents. On consent of both the parties, list the matter on, it's comfortable to you on 30th?
Anytime.
30th, 11/2023.
My lord, in item number 2, which was a joint petition, for a reference, my lord, I have 2 judgments for the record, man, if my allows me.
Mr. Saxena's matter.
Yes, madam. Lakshmi Narayan and Kapil Gupta, my lord, judgment.
You have one more.
There are many, but this is a full bench judgment.
Lakshmi Narayan.
Yes, ma'am.
And
Other one is Kapil Gupta, ma'am.
Kapil Gupta. What is the formula here? What is the ratio?
Basically, my lord, those arising offenses arising out of commercial
It
and.
follows Gyan Singh.
Yes, my lord.
Gyan Singh, 2012.
Yes.
Anyway, thank you. I'll just make a note of that. SCC is there.
Yes, my lord. SCC 2019 5688.
688, para 15.
Yes, ma'am.
I have that. And then
Kapil Gupta, my lord.
2000, this one, Kapil Gupta.
Kapil Gupta. ma'am.
Kapil Gupta.
Basically on same parameters only, my lord.
But it also follows again Gyan Singh. Oh, Gyan Singh is not being considered here. Fine. It is 2022 0 S Supreme bracketed SC 1108. We are gonna be Kapil Gupta. It's on the same parameters.
Same
no?
parameters.
I'll not put it in your name because
My
I'll
lord.
just make a reference.
My lord.
Itu here. Oh, it is going to Yes. Oh, time is it?
Obliged, lord.
We'll not go into that. We'll call for the CD and the next date we will look into it. CD, I'll call for the CD. When do you want it? When can you get the CD? Tuesday? No. 13th of December. No, 30th of November. Fine. Full stop. Heard Mr. MC Modi, counsel for the petitioner. This is an application under section 439 of the CRPC 1973 for grant of bail to the accused Sri Gaimar Takar alias Bharat in connection with Doimuk PS case number 61 of 23 under section 468, 471, 420 IPC. So heard Mr. So-and-so on behalf of the, heard Mr. So-and-so additional PP on behalf of the state. So-and-so. Call for the case records. CD, the call for the case diary. In case of Doimuk PS case number 61 of 2023, full stop. Fix 30/11/2023 for production of case diary. We'll consider on that. I have not read your brief, so I'll go by what you say. What is the problem? Tell me. Where is that impugned order? It's a judgment dated 12/10/2023. In civil revision, criminal revision. And this was preferred against 18-4, the criminal division before against 18-4. Show me 18-4. You also just go through it.
Yes, Your Lordship, I've gone through it, Your Lordship. Your Lordship, here the factum of possession has been decided in favor of the revisionist, the present petitioner. The place where his house house was constructed, residence area, but the other part which is not been decided, which is for which against which there was no any material, Your Lordship, that has been left, and for the status quo order was passed, and they've directed to approach the civil court. So I didn't find any, Your Lordship, irregularity
Let
in
me
this.
just go through it. A particular land dispute has been going on for the complainant is before us now, no?
Yes, Your Lordship.
It is deemed that appropriate transfer of And where is the impugned order? Page? Order of the session judge?
Operating is in 37, Your Lordship.
Operative portion?
Yes, yes, Your Lordship.
Madam, your house is not touched,
Yes.
right?
Yes, but they are still showing this order, that interim order, that the stay is there, you can't make any house.
You cannot, because see, the last page 38, Mr. Heriteji shall not carry out any fresh construction or plantation activity on the land in question, and that land in question happens to be the land other than where your house is situated,
Yes, Your Lordship.
right?
So not in my house. So they didn't clear it.
So do one thing, why? Because see, these are disputed questions here.
Yes, sir.
So how can, because two forums have,
Your Lordship, this is the reason, because the executive magistrate use the power of 145 CRPC.
fine,
And
here,
this is
that has been now, see, that has been now taken care of by the learned session judge.
Yes, and when a session just says that whatever the decision made by the executive magistrate, it is correct. So this is not a correct, Your Lordship. This is a private dispute.
No, see, madam, for a change,
Yes, sir.
the whatever he has said, executive magistrate, we will not go into deep into that now. Whatever he has said, prima facie is only till you approach the civil court.
Yes.
So tomorrow itself, okay, a plaint is not as easy as a repetition. So within a week, why don't you approach the civil court and take appropriate orders? That will redress your grievance. Because even if I pass an order today, I'll be only going through the orders of the session judge, and prima facie, subject to what you can satisfy, nothing wrong there. He also has remanded back you to the civil forum. Please go there and file a case.
But Your Lordship, now I'm in that condition. My house is about to be dismantled, Your Lordship.
How can it be dismantled? Nobody can dismantle your house.
Your Lordship, I'm staying in a kacha house. It's in bamboo
See,
house. Yes, Your Lordship.
see,
So I need to clear that bamboo house, but they are not letting me to do that just because of this order.
you see, come to that page 38. In consideration of all. Mr. Swanson, you just.
Yes, two
clarify-
parts is there, Your Lordship.
Two parts.
Two parts are there.
Ma'am,
Two parts.
just. In consideration of all statements and documentaries, it is deemed that right to title may be decided by the appropriate civil court.
Yes, that is
Right?
Yes.
Mr. Teri Haji has been in possession of the post plot where his residence stand,
Yes, Your Lordship.
so not touched.
Not touch. Yes.
The rest of the plot shall be kept unencumbered and status quo will be maintained.
Yes.
So status quo is, see ma'am, if there is anything, if there is a violation of this order, there are ways and methods to get that done. A revision will not be the answer to that. And you see, and it is strictly ordered that Bamang Taka, who is the other claimant, shall immediately stop all construction and other activities on the said plot of land. That means the plot of land other than where your house is. Heri Taji shall also not carry out any fresh construction or plantation activities on the land in question. That land in question means the land where status quo is given.
Yes, Your Lordship.
So, ma'am, we will not say anything. I'll just issue a notice here. Let it come up next week. And in the meantime, you work it out. And if something you can satisfy, that's a different thing. On Tuesday, Wednesday, we'll fix this matter. Because your house, that condition, it's not overnight. It's continuing for a long time. So it's not that today, if I don't pass an order, tomorrow the house is gone. If the house is going, it's going because it is getting worse over a period of time. Right? So just look into that. Heard, ma'am, your name?
J.
Heard so-and-so for the petitioner. Also heard Mr. So-and-so for the respondent number 1. Issue notice, a full stop, respondent number 1. The petitioner, I'll not say anything. I'll only say
Only issue notice. Your
notice.
Lordship. Yes.
Issue notice. Full stop, so-and-so. The petitioner, the so-and-so, sorry, heard so-and-so, heard so-and-so for the respondent number 1. Full stop. issue notice upon respond number 2, petitioner to take, can you take Dasti? No, Dasti?
Yeah,
Take, sir.
Your lordship, this is a criminal proceeding. Dusty is not,
Dasti will not.
not
require, sorry,
permissible.
Dasti. Take, or we'll not issue notice to respond number 2 now.
Your lordship may issue through jurisdictional PS, your lordship.
Okay. Issue notice. The petitioner to take steps for issuance of notice to respondent number 2 through the jurisdictional police station. Full stop. Steps within 2 days. Full stop. List the matter again on.
Your lordship, notice may not be served within 2 weeks or 3 weeks, your lordship. Because it's a private respondent, your lordship. His presence is required, necessary, because he will be aggrieved party, your lordship.
So what do you suggest? I'll give them 10 days time.
Your lordship, after 2 weeks, matter may
2
be
weeks.
listed, your lordship.
List after 2 weeks. Fix a date for that.
Yes, your lordship. Anyhow, he is protected, your lordship.
2 hafta time hata diyo. 2 hafta we should do. Huh? 13. 13, 12.
Your lordship, 19. This is convenient for them.
19 convenient?
Yes.
19. 19, 12. Full stop. I'll not say anything on the interim prayer now.
Yes, your lordship.
I'm keeping it open.
Yes, sir.
Or should I say that the interim prayer, anything, if any, will be considered on the appearance of the
Yeah, yes, your
respondent?
lordship.
The interim prayer. Malik.
Not required.
Criminal case, there is
Yes,
no-
your
no
lordship. Yes, sir.
What's-
Deeply obliged, sir.
See, I would have considered that if your house is subject to that, somebody is, because of that order, your house is being dismantled or something, then it would have been an urgent thing. We
Your
would have
lordship,
passed some orders.
In fact, I have never seen such a clear order from the
No,
magistrate.
that's what
till
I
date,
said.
your lordship.
I'm surprised. He's given a very reasoned order.
Yes, your lordship.